I've got a great trivia question for you today. If a patient has audio of a conversation she had with her doctor in the office, admitting that he screwed up, can we use that hidden audio at the time of trial without disclosing it to the defense lawyer? You want to know the answer? You think you know the answer? Come join me and I'll share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So the patient comes to me believing that the doctor violated the basic standards of medical care. And during our conversation, she tells me, listen, during my conversation with the doctor in his office, I taped it with my iPhone. I wanted to hear exactly what he had to say to make sure I didn't forget what he said. And you know something? During the course of our discussion, she tells me that he said that he admitted that he screwed up and that he apologized. He was sorry. Can I use that information, that audio tape, against the doctor at the time of trial without disclosing it to the doctor or to his attorney? The answer is no, I can't. If I intend on using that information at the time of trial, I have an obligation to tell the defense attorney about it. I have an obligation to give the defense attorney a copy of that audio recording. I have to send it to him so he knows exactly what was said. He then will be able to prepare a defense for the doctor to explain away whatever he said during the course of that discussion. Regardless of whether or not there's any legality associated with creating that hidden audio tape, the mere fact that my client has done that and now has that proof, if I intend on using that proof, assuming legally I am able to use that, then I am also obligated to give a copy of that to the defense attorney before his question and answer session, known as a deposition, during the course of the lawsuit, pretrial testimony, so that he can prepare his doctor for these questions surrounding that conversation. So here's what's going to happen if I don't give the defense attorney that particular audio recording and don't tell him that we have that recording. At the time of trial, now I get to question the doctor, cross-examination. He'll likely be my first witness. And if I try and spring this conversation on the doctor, you know what will happen? The defense attorney is going to get so upset, he's going to start screaming and yelling and screaming that this is trial by ambush. And then he's going to ask the judge for sanctions for doing something that I'm not allowed to do. Will the judge do it? The judge will have to decide that on a case-by-case basis. But you know what? It would never get to that point because I do have an obligation to disclose that audio recording to the defense way before we ever get to trial. So why do I share this great information with you? I share it with you just to give you an inside look at what goes on in these civil lawsuits involving medical malpractice and accidents and even wrongful death here in the state of New York. You know, I recognize that you're watching this video because you probably have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but yet you have legal questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, there's something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.